My apologies for having to speak in English. My Spanish is unfortunately, well, non-existent, so this is the best I can do. But thank you very much for Professor Sanchez for the gracious introduction and for making it possible for me to be here, and especially to you and Professor Botero for making me feel so welcome here. Dean San Pedro, thank you, and I'm also grateful that Father Alvarez could be here to welcome us with his remarks. So I'm going to talk about two topics. One is corruption. As you heard from Father Alvarez, it's an important topic. I gather it's an important topic here in Colombia. It's a significant problem in Colombia, but it's important for me to say that it's a problem almost everywhere I go. Right? Everywhere I go, whether it's in Argentina or Brazil or sadly in the United States as well, people are concerned about corruption. Everyone wants to talk about how corrupt their politicians are, what they can do to lock them up. They're complaining, they're very sad about how many cases are going on, how many investigations, how much time corporations are spending investigating and trying to control bribery. The funny thing is, you'd think these things would be sad conversations, but they're not always sad. Maybe it's because I'm speaking to a lot of anti-corruption lawyers, but they seem to often be quite happy about the number of cases and the amount of investigations. And well, anyway, that's just a problem with the audiences that I'm typically speaking to. But what I do want to talk about is corruption and how to control it and what works in controlling corruption. So that's one topic. But the second topic is somewhat broader. And it's how do we use empirical evidence to help us decide how to control corruption? How do we use empirical evidence to tell us what works? And I'm going to talk about a movement that has been gaining a lot of momentum, not only in the United States, but in the OECD and also more broadly, towards what's called evidence-based regulation. Right? The idea of basing your regulatory decisions on empirical evidence, systematic empirical evidence. And so I want to talk about that idea and explain what it is, but also talk about some of the limitations. So what I'll do is I'll first of all start off with a little bit of law. Talk about what I think of as the global anti-bribery regime, which is actually quite a complicated body of law. And so we should make sure that we have a sense of what's entailed in that. Then I'll talk about what is evidence-based regulation, because it's really a term of art. It has a very specific meaning in the literature these days. And then we get to the core of the argument, which is the strengths and the limitations of evidence-based regulation. Okay. After that, we can talk about anti-corruption law again and talk about three specific proposals that have been made, three specific ideas about how to design anti-corruption regulation. And we can think about the extent to which evidence, empirical evidence, will help us to make those decisions, help us make decisions about whether those designs are appropriate. Right? So that's where we'll go. Okay, so first of all, let's see. Corruption, like I said, is a problem everywhere. I was doing a little bit of research, and this was a remarkable case, truly remarkable. Senor Gustavo Moreno, as you know, is now this is a picture from his extradition to the United States where he's being charged with accepting bribes. I'm sure most of you know the story, while he was chief of the anti-corruption agency. Sadly, this is not atypical. You can find similar stories in lots of countries. Okay? So that's one example of the kind of law that we're going to be talking about. The other case, which I suspect is also familiar to many of you, the Odebrecht case. Again, this is one of the largest anti-bribery cases ever in the United States, probably the world, where, as again I'm sure you know, Odebrecht, the Brazilian construction company, was prosecuted in the United States initially, and Switzerland and Brazil, for paying bribes in a dozen different countries. They settled to pay $3.5 billion. That was the initial agreement, to pay $3.5 billion to those governments. And as I'm sure you know, they're being prosecuted in all these other countries as well. Right? So that's, again, another example of the kind of case that we're talking about, the kind of problem that we're discussing. Okay? So in terms of the legal regime, I'm going to focus on anti-bribery law, not anti-corruption law generally, but just anti-bribery law, the body of law that governs when public officials accept bribes. And so just about every country prohibits bribery of its own public officials. That's step one. Step two, most countries in the world prohibit bribery of foreign public officials, prohibit the payment of bribes to foreign public officials. And that's actually mandatory under the OECD Convention. So that's step two. That was initially, that idea of prohibiting bribery of foreign public officials, it started in the United States, basically, with something called the Foreign Corrupt Practices Act. And so as I go through this talk, I'll keep referring to the FCPA, the Foreign Corrupt Practices Act, just because it's still probably the most prominent example of anti-bribery legislation in the world, and a lot of the prosecutions of transnational bribery involve the FCPA and the US authorities in some way. Okay. There's also anti-money laundering law. Senor Moreno is actually being prosecuted in Miami for money laundering, not under the FCPA. The FCPA only covers payment of bribes. It does not cover the receipt of bribes by foreign public officials. So for the Americans to be able to prosecute him, they have to rely on their money laundering laws. So that's another very important part of the regime. Something I didn't put on the slide is that all the OECD countries, Colombia, all the countries that are members of this OECD convention, they impose corporate liability for bribery. So corporations whose agents can pay bribes can be held liable. So that's an important feature of it. Sometimes the corporations are required to have internal controls, mandatory compliance programs. That's another body of law that's important in combating bribery. On the other side, for the officials, you've got illicit enrichment laws, etc., etc. So it's quite an elaborate body of law. Right? Leaving aside that criminal legislation, you've also got the types of sanctions that are imposed by the development banks, the Inter-American Development Bank, the World Bank, the African Development Bank, the Asian Development Bank. They all have systems for doing what's called debarring. So banning companies that pay bribes on projects that are sponsored by those agencies. So this was again a problem for Odebrecht, as some of you know, with the IDB. They bid on many projects that they paid bribes to obtain contracts for projects that were funded by the IDB, and so the IDB could consider debarring them. And then in arbitration, and this is going on in the Odebrecht case as well, some of those contracts can be set aside, can be avoided on the grounds that they were procured through bribery. So that's the law that I'm talking about. That's what I call the anti-bribery regime. And it's a global regime because it doesn't just involve people in one country, prosecutors in one country, prosecuting people who pay bribes to the local public officials. As you can see in the two cases that we've been talking about, the Moreno case, the Odebrecht case, it can be many different prosecutors. Right? It can be companies paying bribes to foreign officials receiving bribes from foreigners, being prosecuted by third, fourth, fifth, sixth countries under a variety of regimes, and sometimes all at once, right? And then they can be subject to proceedings before the World Bank, the Inter-American Development Bank, in arbitration. So it's actually very complicated, right? It's what you can consider, what I would call a multi-level system of governance, because you've got authorities at the local level, the national level, the supranational level, right? Imposing the regulation, creating their own norms, and they have overlapping jurisdiction. Okay, so that's the context, the regulatory context that I'm going to be focusing on. Not a simple one. Now to the other topic, the other part of the talk. Evidence-based regulation. What is that? This is a term that originated actually in medicine with something called evidence-based medicine. This is a movement that began in the early 1990s where some medical scholars decided that it was important for doctors to do more than just rely on their clinical judgment in deciding how to treat patients. Right? they decided that doctors should actually try to take advantage of the best available evidence, the best available scientific evidence in figuring out how to diagnose and treat their patients. It sounds like a very commonsensical idea. Instead of just relying on their own personal experience or a few anecdotes or a handful of cases, case reports that they've read, they should look at the scientific literature, look at the clinical trials that have been done, the experiments that have been run, to try to figure out what to do. And that should guide their treatment decisions. So that was evidence-based medicine. And one of the important features of it is that it encourages doctors to question the evidence, and to establish a hierarchy of evidence, to say that some evidence is better than others. Case reports are good, but tens of case reports are better, where you compare across a large population. A statistical analysis of multiple cases is even better still. And ideally, you would have what's called a randomized controlled trial, where you randomly assign people to receive a treatment. So some receive the treatment at random, others don't. And then you look at the results, and that tells you whether the treatment is effective. The randomized controlled trials are considered the gold standard of evidence, right, in this model, except for surveys of multiple randomized controlled trials, which are obviously even better. Right? So the idea behind evidence-based medicine was to make decisions on the basis of the best available evidence, which, typically places a priority on evidence that comes from systematic research, rigorous systematic research. So that's evidence-based medicine. That idea has recently been extended to other areas of public policy. So you'll see a lot of economists now who are advocating evidence-based policy making, and they will do randomized controlled trials to figure out whether things like introducing flip charts into schools are effective, or cameras in schools to make sure the teachers are there, or deworming programs. There are all sorts of programs that are being tested using these randomized controlled trials. The idea is to figure out whether they are actually working based on the best available evidence. Okay? So that's what's going on in economics. Now the idea has come to law. Right? There is some legal support for the idea that regulation should be based on the best available evidence. So in the United States, in 2011, President Obama at the time issued an executive order to the regulatory agencies under his control, saying that their regulatory decisions had to be based on the best available evidence. That idea is actually very strongly promoted by the OECD, which is, in all its publications, advocates for evidence-based regulation. These ideas come from academics and are supported by academics. Down here, Cass Sunstein, who was probably the most famous law professor, certainly in the United States, the most cited law professor in the world. He's currently at Harvard. He used to be in the Obama administration, and he actually played an important role in drafting that executive order. He firmly believes in the use of evidence to guide regulation, and especially social science evidence. Right? And he has a long law review article making that case. Ian Ayres, who's also one of the most famous law professors in the United States, he's at Yale University. He and some co-authors have an article arguing that we can use randomized controlled trials in law, right? And I'll talk about that article a little bit more later on. So they're promoting it. And recently the idea has gone beyond the United States, and now this idea that you should base regulation on the best available evidence is actually embodied in the Trans-Pacific Partnership Agreement. Which I use the new name for it, the CPTPP, yes, which is the new name after the United States withdrew. But in their regulatory coherence chapter, there's also this requirement to use the best reasonably available information, right? Which you could interpret as a mandate for evidence-based regulation. Right? So that's the support for this idea. And there are a lot of NGOs, there are a lot of practitioners who do this, right, around the world. They do this in the context of all sorts of regulation, but what I want to talk about is, well, what are the advantages and disadvantages of the evidence-based approach? The advantages, or the benefits, I think are quite important. They're quite significant. First of all, the scientific methods that have been developed over the course of the past 300 years, say, since the Enlightenment, the beginning of the Enlightenment. They are very good methods of determining what has happened. Scientists have become very adept at identifying patterns in data, right? And seeing what has worked in the past in our case. So if you've got regulatory interventions on one hand, you've got outcomes on the other hand, social scientific techniques can help us identify those patterns, right? And quite often, that will help us figure out what's going to happen next with the same interventions. So Mark Twain once said that history never repeats itself, but it often rhymes. Right? So there is something to be learned from the study of those patterns, what has happened in the past. And that's the premise here, that you will get some insight into what has worked and get some insight into what will work by looking at what has worked based on this kind of rigorous analysis. That's one benefit. The other benefit is that the essence of most scientific methods is transparency. You have to show your work, you have to show your methods. Right? And that makes them open to challenge. That gives people an incentive to be more reliable, to be more accurate, so that's one benefit. It also enhances accountability, and democratic accountability, and so that's another important benefit to the evidence-based approach. And I think it's important to remember that, because for the rest of the talk I'm going to raise some criticisms or suggest some limitations of the approach, but I don't mean to suggest that it is not valuable. And I know this talk is, some of the criticisms are, well, not always well received by my fellow academics. I had that experience last night with Professor Sanchez. She was very polite, but and I think it's because a lot of us have an interest in promoting empirical work, because that's what we do, and that's what I do in many contexts. But it's more than that. I think we're also very committed to the idea that we can learn about the world through systematic inquiry. Right? Again, this is an Enlightenment ideal that we in the university, we in the academy are deeply committed to. Right? And so it's important to recognize that. It's almost like sometimes telling people that you should abandon or limit your use of evidence-based research. Telling an academic that is almost like telling the Pope that he should use Google to write his sermons. Right? It's just not the way it's done. Right? That's not the right tool. But I'm going to suggest that there are occasions on which we want to use something else. We might want to look at judgment, right? And here are the reasons why. Okay? So the kind of systematic research that is prioritized by the evidence-based approach, it involves 3 steps. First, you go out and collect your data. You figure out what sort of regulation was introduced in various places, whether it was introduced, where it was introduced, when it was introduced. And then you look at what happened. So data on the interventions, data on the outcomes. Right? That's step 1, you collect the data. Then you do an analysis. Try to draw causal inferences. Try to figure out the causal relationship between the intervention and the outcome. Right? And then you try to figure out whether the intervention you're interested in is going to play the same role in your new context. Because you're trying to figure out what has worked in the past to see if it will work here. Will it work in Colombia? Right? So those are the 3 steps. And you can see that there are problems that could arise at each of those stages. Right? First with the data. Sometimes data is bad. Sometimes it's difficult to collect. Sometimes it's non-existent. Right? So that's one step. Secondly, causal inferences. They're hard to draw. You've probably all heard the expression, correlation is not causation. It's hard enough to find the correlations, but sometimes you can make mistakes in determining whether or not there's that causal connection, whether one event actually caused the other. Right? And so that's the next challenge. The third challenge is generalization. Right? It's not always true that what happened and what worked somewhere else will work here. Right? History doesn't necessarily repeat itself. Right? So that step, that generalization, can be challenging. And then finally, I spend a lot of time thinking about the role of law in relatively poor countries. Right? And one feature of poor countries, and especially smaller countries, Colombia is large, but smaller countries and poorer than Colombia is the lack of capacity. Right? There are countries in this world where the government just doesn't have that many lawyers and social scientists to assist them in deciding how to make regulation. This evidence-based approach requires a lot of capacity. And for that reason, it may not always be appropriate in every context, right? Which is independent of some of the other points. And what I want to argue is that we can actually, if we think carefully about it, identify some specific types of contexts in which evidence-based regulation is likely to manifest these problems, in which these limitations are likely to be quite significant. And what I'll argue is that those contexts are likely to involve regulation that's complex, where there are lots of actors, multiple regulators with overlapping jurisdiction doing the same kind of thing, where you're concerned with illicit activity, right? Which is a situation where the data are typically hard to get, hard to obtain. If it's transnational, not just transnational, but global and includes some relatively poor countries, or certainly a diverse selection of countries, you're likely to involve countries that have limited capacity. Right? And so for all those, in those types of situations, it's going to be hard to get the data, it's going to be hard to draw causal inferences. What's happened in the past may not play out exactly the same way in the future just because the situation is so fluid and complex. Right? And you're going to be dealing with capacity constraints. So that argument is not that evidence-based regulation is always unhelpful, but there are some identifiable contexts like these where you're dealing with complex global business regulation of illicit activities in which it's less likely to be helpful. Right? And this is where we come back to corruption. I'll suggest that the global anti-corruption regime, and certainly the global anti-bribery regime, is a classic example of this kind of regulatory context. Global, complex, dealing with illicit activity, involving a large number of relatively poor countries with limited analytical capacity. Okay? And so, just to work through the argument, I'd like to use 3 examples. Okay? Talk about examples of 3 types of anti-corruption initiatives, 3 sort of regulatory interventions, regulatory designs that we might want to analyze, that we might want to think about whether they're a good idea. And we can look at whether the evidence-based approach actually helps us make that decision, right? Helps us with the analysis. Okay? Okay. So, the first intervention, here we go. Specialized anti-corruption agencies. Right? Should you have a dedicated anti-corruption agency, not just an office in the Attorney General's office, not necessarily just a coordinating body, which I gather we have here in Colombia, but an independent agency that is dedicated to doing nothing but corruption, that has multiple functions like investigation, sometimes prosecution, is responsible for coming up with suggestions for prevention, right? Public education, and also conducting research. And there are examples of agencies like this. The most famous example is the Hong Kong Independent Commission Against Corruption, which was established in 1976. Singapore also has a similar agency, and they've been very successful. Those are the best cases, right? So the question is, should we create this kind of agency? Right? Theory points us in different directions, right? There's some clear advantages to specialization, to having these activities all under the same roof, keeping the anti-corruption people separate and apart from other branches of government, so they're less likely to be captured, and their resources are less likely to be diffused amongst the other agencies. Right? So those are the theoretical advantages. The disadvantages we can also figure out. They're quite obvious. The isolation from other agencies, and the lack of competition. Right? There's an important school of thought that says that, Well, one way to make sure that you have an effective anti-corruption effort is to encourage lots of different bodies to get involved, give them opportunities to compete for cases. And we certainly see that in Brazil, for instance, right? You can argue that part of what made Lava Jato possible was the fact that the operatives of the Ministério Público in Curitiba could work on their own. They were not subject to some sort of centralized control. And then the Department of Justice in the United States could operate independently of any centralized Brazilian agency, any centralized international agency, etc. So there's a strong case to be made for competition. So theory points us, in different ways, in different directions. What does the evidence say? Well, what type of evidence could we look at? We could look at case studies, first of all. That's an important type of study, right? The advantage of case studies is that they're richer, and you can not only figure out what happened, so we had an anti-corruption commission in Hong Kong, we had all these great results, the number of complaints of corruption doubled almost overnight, the police syndicates, which were highly corrupt, disappeared within a few years. Surveys later suggested that corruption went from being routine in Hong Kong before 1976 to 10 years later, people thought Hong Kong was a clean city. Right? So the case study shows us the intervention and the outcome, but it also allows us to trace the process, trace the mechanisms that led to those outcomes. We can say, oh, well, it's because you had this preventive component. Right? They made suggestions like legalizing gambling, off-track betting, and horse racing. Right? There was a public education component. You can see that worked. There were some high-profile prosecutions. You can work through those mechanisms to figure out what worked in Hong Kong, right? And think about whether it might work in Colombia, in Uruguay, in Peru, whatever. Right? The problem with case studies, though, is they're not necessarily representative. Colombia is not Hong Kong. Right? There are many differences, starting with the size. Right? So you might want to look at other types of evidence as well. Right? For a lot of us, the natural place to go is some sort of cross-country statistical analysis. Right? So where we look at many cases in which anti-corruption agencies were introduced and see what happened. Okay? And there's a scholar, a Romanian academic who teaches in Germany, actually, Professor Alina Mungiu, who's done some amazing work collecting data on the types of anti-corruption regimes we see in at least 99 countries. This version of the study had 99 countries in it. So she's collected all this data about the anti-corruption regimes, including whether or not they have anti-corruption agencies. She also has data on levels of corruption in those countries over time, and she looked from 1996 to 2011 at whether the countries that introduced anti-corruption agencies actually ended up having less corruption. She did it in two ways. The first way was by looking at each country, basically, and seeing the before and after, comparing what the country looked like before the anti-corruption agency was introduced and what happened after. So the level, looking at the change. And that's what you see here. Right? So this chart, you can get the general idea, I think. The y-axis, the vertical axis, shows the level of corruption in the country on a scale from 1 to 6. And it's based on data from a company called I'll just say ICRG, which uses experts to measure, uses experts' analyses to measure the level of corruption in the country. And they do it regularly, right? So they've got that data over time. On the x-axis, you've got time. But this is time in relation to the date at which the anti-corruption agency was established in each country. So it's a complicated kind of graph, but I think you get the idea, right? So what this line is showing here, the dark-colored line, is for the average country, what happened to the level of corruption in the period of time around the introduction of the anti-corruption agency. And you'll see that in the typical country, I'm not sure this is, okay, that's not working, but you can see that in the typical country, the level of corruption was declining before the introduction of the agency, and then it declined a tiny bit more, typically, but not very much. And statistically, it was not a significant decline, right? And in fact, 5 years later, it started to go up again. So what she takes from that analysis is that the introduction of anti-corruption agencies did not have a significant effect, a significant positive effect on the level of corruption in the typical country. Right? Those bars show the error range, right? Because she actually has 99 countries. So the line is the median, let's say it's the mean, it's the average, but the range of outcomes is shown by those bars, and once you take that into account, you see, we can't say anything. There's no evidence that the anti-corruption agencies are really helping. Okay? So that's the time series analysis, the analysis based on analysis over time, the before and after. She does something similar looking across countries, right? And has the same results. So when you compare the countries with anti-corruption agencies to the ones without, you don't find a significant difference in the level of corruption. Okay? So that's an example of a statistical analysis that might help us figure out whether an anti-corruption agency works. Right? In this case, it suggests it doesn't. And an evidence-based approach to anti-corruption, to the design of anti-corruption institutions, would presumably look at this kind of analysis as well as at the case study that we showed. I think it's important, though, to recognize the limitations of this kind of statistical analysis. Right? So let's start with the data. Right? There are two types of data in there. There are data on the intervention, so was there an anti-corruption agency in place? And there are data on the outcomes, right? The level of corruption. Both of those are of less than ideal quality, shall we say. And this is something that Professor McGee would acknowledge. She's very upfront about this. Right? And I do think this is the best example of this kind of work that you can find. But as far as the data on the interventions, all we know is yes or no. Was there an anti-corruption agency or not? We don't know what its powers were, how it was staffed, the training of the people in it, right? The level of funding, what sort of relationship they have with the other branches of government. None of that data is in there, right? We've got these very imprecise measures of the intervention. So that's one limitation of this, right? On the other side, with our outcome variable, the measure of the level of corruption, here are more critical. First of all, who are these experts? It turns out we don't know who they are. So who is it who's telling us about the level of corruption in Colombia? You can't actually figure that out. How are we supposed to know how accurate they are? Why would you expect them to be accurate? How do they know what's going on behind closed doors and what's in those envelopes and what's in the briefcases when you're dealing with an activity like corruption, high-level corruption especially? It's a difficult phenomenon to measure, especially if the experts are outside the country, which is the case for some of these. Right? There's also the point that these experts are reporting their perceptions of the level of corruption. They're not saying, well, this has been my experience with corruption, or here's some empirical, some data that we've collected from the banks that shows how much money is being smuggled out of the country. It's nothing like that. It's just perceptions. And perceptions are not the same thing as reality. Perception measures for corruption are particularly problematic, and here a lot of prosecutors complain about this. I was at a meeting at the United Nations a few months ago, and this Italian prosecutor, he went away from his script, which almost never happens at the United Nations, and he suddenly started complaining about all these measures of corruption, saying, well, the better job we do in fighting corruption, the more cases we bring up, the worse our country scores on these corruption measures. Because the more we find, the more people think is out there. And that's a very significant problem with perception measures. Even if they accurately measure perceptions, that's not the same thing as the reality. And sometimes we care about the reality. Sometimes we care about the perception, but the reality is also important. So those are two limitations of the data. In terms of the causal inference, this idea that, well, we can look at that data, even let's assume the data is perfect, you can look at that data and say, well, introducing an anti-corruption agency didn't work, right? Because we see the before and after. We have to recognize that the countries that decided to adopt anti-corruption agencies were not randomly selected. This was not a randomized controlled trial where you randomly assigned the agencies, you sprinkled the agencies at random over the countries in the world, and then you saw what happened. No, there's some other factor that drove them to adopt those agencies. And that same factor could be explaining not only the adoption of the agency, but also the results we're observing. And it's hard to control for that. Right? So it could be the case that the countries that adopted anti-corruption agencies are the countries that thought they had a problem. Right? They thought that things were going well, but they saw a slight uptick. They thought that corruption was going to start getting worse, and so they brought in an anti-corruption agency, and it made things better than they would have been. Right? That's possible. I have no idea, but you can't rule that out with this kind of statistical analysis because you don't know what you don't know. You can't observe the variables that you haven't measured. Right? Like people's expectations about the future course of corruption. Right? We could tell different stories about this. There are other omitted variables that could point in the other direction. But it's a standard limitation of this kind of statistical analysis. Okay. Of course, there are questions about generalizability. This study covered the period up to 2011. Things that might have changed. We might have gotten better at controlling corruption. Maybe anti-corruption agencies are more effective. Who knows? They can use big data. And if you're also looking at this for Colombia, right? If the question is, should we adopt an agency like this in Colombia or change the agency you have to be more like the typical international agency? Well, who says Colombia is the typical country? Who says it's on that line as opposed to either at the top or the bottom of one of those bars? Right? You never know. So generalization is a problem. Okay, so that's one example. Second initiative, mandatory compliance programs. Some of you may be familiar with this topic if you've had any exposure to anti-corruption practice in a big law firm and so forth. It certainly generates a lot of work for lawyers. So, the theory. The theory is that when you're dealing with bribery, a lot of it involves bribes paid by employees of corporations, large corporations quite often, to public officials, say to get a contract. Okay. You can try to discourage those employees by threatening to throw them in jail, right, through public enforcement. But you might also find it useful to encourage private enforcement, to encourage the firm, to encourage their employer to do things like try to prevent them from paying bribes in the first place by not doing business in certain areas or controlling their access to cash. You might encourage the employer after the fact to monitor where the money has gone, right, to try to detect improper payments, to investigate suspicious transactions, to punish employees, to sanction employees who engaged in bribery, and also to report them to the public authorities. Right? All those forms of private enforcement might be useful because the company, with its superior access to information and its level of control over the employees, might be in a better place to undertake all those types of enforcement activity than the public enforcement agencies. So it could even be a substitute for public enforcement. But it also complements public enforcement to the extent that the company can generate information that can then be handed over to the public authorities. So that's the idea behind all those internal investigations that you'll hear being conducted by large law firms of companies like Odebrecht, right, and the compliance programs that certainly the US prosecutors encourage large firms to adopt. Okay? So that's the theory. What about mandatory compliance programs? Should you have regulations that require companies to do all those things, to prevent, investigate, report, and assign a compliance officer or many compliance officers to those tasks? What about making it mandatory? There are some advantages to that, right? Instead of relying on the threat of being punished for bribery, corporate liability for bribery down the road, you could just make it straightforward. Because the threat of liability, that's remote. Right? It only creates an incentive, actually directly for the company, right, It's uncertain, because sometimes you don't get caught. You get caught a long time in the future. And the incentives are difficult to calibrate because lots of different agencies are imposing these penalties, right? So whatever incentives to create compliance programs are coming from the threat of corporate liability for bribery, they're very muddy and they're difficult to fine-tune. The most straightforward thing to do if you want a company to have a compliance program is to say, have a compliance program. And that's what some jurisdictions do to a limited extent. Certainly in France, under the new CEP2 legislation, that's what they do. Certain large companies are required to do this. In the US, to a certain extent, the FCPA's requirement to have internal controls requires this. I gather in Colombia, there are certain internal control requirements for certain firms that move in this direction. Right? So the question is this a good idea or not? Lots of advantages. The disadvantages is that, well, do regulators really know how to design a good compliance program? Do they know when the costs of this kind of program are going to be outweighed by the benefits? Because they're very expensive. And prosecutors who in the United States are often people who didn't want to go into business, they have no business sense whatsoever, are probably the last people making these kinds of decisions about how to govern a large multinational company. So that's the drawback of mandatory compliance programs, right? Maybe the costs will outweigh the benefits. Okay. We don't know, right? We don't know whether this is a good idea to have mandatory compliance programs. What does the evidence-based approach suggest? Well, go look at a study, conduct a rigorous study of this. And some academics, including Ian Ayres, who I mentioned earlier on, and his co-authors, have suggested, well, we can do what the doctors do with this. We can actually have a randomized controlled trial of mandatory compliance programs. Right? We can tell some firm, we can pick some firms at random and say, you have a compliance program, you have to have a compliance program, and the rest don't. Okay? And then we can wait a while and look at the outcomes. So the idea is this one. You have the population of firms, you pick a sample of them, you randomly say some of them get the treatment, which is they have the compliance program, the others are in your control group, they don't have the compliance program, and then you compare the outcomes at the end. Just like in a clinical medical trial. And then you'll have the best possible evidence. Because unlike with that statistical analysis that I suggested earlier, you randomly assign the companies to the treatment. Right? So you know that if there's a difference between these two groups, it's almost certain, especially if you have a large enough group, that that difference is caused by the treatment. Because nothing else should be different about the two groups of firms. That's the beauty of these randomized controlled trials. You eliminate these unobserved factors. Okay, so that's the proposal, which I think is a very creative one. It's not foolproof, though. Companies and regulation are different than human beings and drugs. So you can observe the compliance costs in these companies, maybe, but you won't be able to observe the levels of misconduct, right, in the two groups, because a lot of that is hidden. Right? You're not going to catch all the people in either group who actually paid bribes. So there's going to be some noise there. And then, more importantly, the reason these randomized control trials work is because you assume that the control group and the treatment group are separate. Right? The treatment group gets the treatment, the control group does not get the treatment. But if the treatment somehow affects the control group, then it's all messed up, right? To use a technical term. And in this context, we can see at least two ways in which you could have that kind of contamination, or what would be called a spillover effect. First of all, if these are firms, they're going to be competing with one another. What's happening to the treatment group is necessarily going to affect the control group through the marketplace, through the forces of competition. Right? And you can imagine a situation in which the control group decides, well, we have to keep up with these companies. I've forgotten which one I said was the treatment group and which was the control group. The firms that do not have compliance programs. Right? Will find it easier to bribe. Right? The other set of firms might feel compelled to compete, to keep up, right, and pay bribes to compete. That's one sort of contamination, right? Just through the competitive dimension. Right? The other effect is they might see one another. Right? They might hear about people paying bribes in the group that doesn't have to have the compliance programs. Right? And you know how people are. They emulate one another. Monkey see, monkey do. Right? And so, I'm being very technical now. And if you have that sort of emulation, those sort of informational spillovers, let's say, between the treatment groups and the control group, again, the validity of the experiment is going to be tainted. Right? The validity of the trial. You can't draw that inference about the differences. So you could end up in a situation where you don't see that much difference between the two groups. So you might say, oh, we can get rid of these mandatory compliance programs, for example. But no, it's because the ones with compliance programs were feeling compelled to keep up with the others. Right? And that's why they converged, for example. Right? So that's the concern you have with these kinds of randomized controlled trials. There are also generalizability issues. Let's say you run that sort of trial in the United States with firms subject to the FCPA. I don't know whether it will be informative for firms in Colombia with different cost structures, et cetera, et cetera. And then there's a capacity issue. These randomized controlled trials are very difficult to design. They require a lot of statistical expertise. They require a lot of on-the-ground help just to make sure that the firms are complying with the protocol and so forth. That might be missing, right, in some countries. Okay. Last point, and I'll deal with this example quite quickly so we can get to the question period. This idea of leniency. So, certainly in the United States, there's a practice of granting leniency to firms that cooperate with the authorities. Right? What does that mean? It means self-reporting. That's the most obvious form of cooperation. It can mean, even after you're caught, handing over evidence from your internal investigation. It can mean paying compensation to victims. There are lots of forms of cooperation. There are advantages to this, right? Again, in theory, you can think of advantages and disadvantages. The big advantage is that you deal with the firms that didn't prevent the misconduct, but can still do a lot of good things in terms of investigating and reporting. And you're giving them incentives to make up for the failure to prevent by investigating, monitoring, self-reporting. Right? So that's a good thing. And that in turn helps with the ultimate goal of punishing them, right? And punishing the employees, which can be effective in terms of deterrence. Okay. The disadvantage is, if firms know that even if their employees pay a bribe, they can get leniency, that reduces their incentives to engage in preventive activity. Right? So that's the drawback. Also, some people think that it dilutes the expressive force of the law if you're cutting deals with these very corrupt companies, with Odebrecht, with Marcelo Odebrecht. You know, some criminal lawyers especially have a problem with that. So those are the advantages and disadvantages. Can we study them? Oh, sorry, I should have put this up. What the US government did when it wanted to study a sort of fine-tuning of its leniency program was they introduced a pilot program. Right? The US Department of Justice for 18 months had a pilot program that made it very clear what would happen if you cooperated. Right? It said, if you self-report and cooperate, then you're going to get a 50% reduction in the fine. We're probably not going to impose criminal liability. We're not going to impose a monitor who will scrutinize you after the fact. Okay. And even if you don't self-report, even if we catch you, we will still give you a 25% reduction in the fine. Right? So there's still an incentive to cooperate, even if you haven't self-reported. Right? And it was such a clear and simple program that some private company could go and produce this, right? This little pictogram showing exactly how the program worked. And that was the idea, to make it very, very clear what sort of leniency you would get if you self-reported and cooperated in order to generate all those benefits. Okay, and that's the more precise definition. They think it worked, right? So they tried it for 18 months and then they made it permanent. And they looked at the data internally, and one of the things they found was the number of firms that walked in the door and said, we paid bribes, increased from 18 in the 18 months before the pilot program was initiated to 30 in the period after, right? In the 18-month period of the pilot program. That's a big increase. I mean, as a social scientist, you might quibble and say they didn't control for this variable, they didn't control for that variable, but with an increase of that magnitude, it's probably because of the program, right? I think that's a safe causal inference to draw, okay? So, based on that evidence-based approach, the US government adopted the leniency program. It's not a perfect test, though, right? Because we know that, I think we know, that the pilot program caused this increase in self-reporting. And that's an easy thing to measure. The data of that is very good. You know who's walked in your door, right? And the numbers, right, make the inference fine. They didn't actually figure out whether the program induced firms to do more prevention or less prevention, which is one of the big concerns that you'd have in theory. They're not measuring that. That's hard to measure, and they didn't, and they couldn't even pretend to, right? So that's, a quibble with this, more than a quibble perhaps. Right? And then again, the generalizability. I actually am convinced by this. I'm comfortable with the idea that on balance this was a positive intervention in the US context. I'm not sure what that means for other countries. Right? For instance, in a jurisdiction where you've got a lot of owner-managed firms, right, which is most of the world outside of the US and the United Kingdom, actually. Will the promise of leniency for the firm actually induce the owner-manager to come forward? Probably not, because that usually means, the whole idea of leniency in the US context is that it gets the company to cooperate and provide evidence that can be used to prosecute the individuals. Right? If the individual is also the owner and the manager, this argument falls apart. You don't have the same incentive effect. The fear of going to jail is going to be a much more powerful incentive than the prospect of getting a 50% reduction in the fine for your company. So the analysis you would expect, even as a matter of theory, to change in other economies. Right? It also, when I talk to some of my Brazilian friends, they say, well, there's this reluctance to cooperate. Right? There's much more suspicion of the state in some countries than you might find in the US. And resistance to squealing on your colleagues, right? So if you have any sort of cultural difference like that, again, the results might be different. It might not be possible to generalize. So that's the concern there. Right? A limitation, as it were, of the evidence-based approach. But again, I found this pilot useful. I found this evidence very useful in the US context. My main concerns here are actually about the generalizability, not about the application of the evidence in the US context. Okay, so that's those are the three examples, and that's the argument, right? Again, the main points are if the limitations of the evidence-based approach come from the data, right? Sometimes data is difficult to collect, sometimes it's difficult to observe, but especially without any sort of error, especially in the case of illicit activity. I won't go through the rest of these slides, of the material on the slides, but it's, you can imagine there are a lot of reasons why data on outcomes could be difficult to observe, but also data on the interventions. Okay. Probable causal inference, when you're doing case studies, we don't know if they're representative. When we're doing statistical analysis, and I'm going to hit the highlights of the slides here, we've got the admitted variables concern, like in that statistical analysis of the anti-corruption agencies. And with randomized controlled trials, we have, skip the technical point, but we have that big problem of preventing the treatment from affecting the control group. When we're talking about law, law is very public. It's hard to control its impact and to limit its impact to a treatment group as opposed to a control group. It's very different from handing someone a pill. a generalizability in these very complex situations, I think, where you've got lots of factors affecting the outcomes, which I think is typically the case when you're talking about regulation and behavior, again, as opposed to, say, environmental outcomes, environmental impact, or health impacts, you will have serious concerns about generalizability. The world is a big place, countries are very different. And then finally, there are the capacity constraints, which are, I think, not to be underestimated. Maybe not in a big country like Colombia if you're talking about national legislation, but in poorer countries, at the subnational level, that is a meaningful concern. So, the implications, again, evidence-based regulation is not perfect, but it is good. I should emphasize that. And we should never let the perfect be the enemy of the good. But we have to recognize the situations in which it's not necessarily better than the alternative, right? Of relying on judgment, experience, even anecdotes, a certain amount of theory, right? Where the evidence is just not that helpful. Right? So you should do the best you can to try to improve the quality of the evidence, gather more data, improve your analytical techniques, improve capacity. Right? But you also have to be prepared for the possibility of sometimes relying on judgment, sometimes relying on hybrid approaches, like finding ways to systematically capture the judgments of experts, right? Thinking carefully about who the experts are, polling them, but being rigorous about it. And that's a hybrid kind of approach. And sometimes even making evidence-based decisions about whether to have an evidence-based approach. Trying it out. See what happens if you ask prosecutors to follow an algorithm that's derived from research, as opposed to relying on their own judgment. You can imagine doing a randomized controlled trial of that. Right? A randomized controlled trial that tests the merits of the evidence-based approach. So that's about all I wanted to say. Hopefully this has given you a sense of the kinds of things that I think are important for us. It's not just the problems like corruption, which are incredibly important and serious problems, but also our role as legal researchers is to think about, well, what tools should we use to tackle those problems? What sort of methodologies, what sort of theoretical approaches should we adopt? And the doctoral students in the room, I encourage you to always reflect on those kinds of methodological questions, because they actually are important. A lot turns on them. Okay, so with that, thank you very much, and I look forward to your questions.